So people are something one day is good one. Will you have something about it? Whatever says. Okay, see you tomorrow. Which are pertaining to they will discuss it.
Lordship, yes, I may be allowed to make a mention for 24 and 25. They are connected. 24 is the IA. Lordship, I am for the respondents 1, 2, and 8. I have written a letter to the seeking instructions, but the instruction is still awaited, Lordship. So if it can kindly be listed after 2 weeks.
Learned Counsel representing respondent number
1, 2, and 8.
1, 2, and
8.
8 submits that he is awaiting his instruction. Accordingly, praise for an adjournment.
Yes, my lord.
Prayer is allowed. List this matter
After 2 weeks, Lordship.
after 2 weeks.
My name may kindly be reflected.
Look, yes, your name, good name, please.
Sentianga,
Sentiel.
deeply obliged. Lordship, I also have a prayer for hearing item 39, Lordship.
Yes,
If it can kindly come up after 3 weeks.
3 weeks.
Lordship, and in item 8, I have received the affidavit in opposition just now.
Okay.
So, with the consent of my learned friend, if it can kindly come up on 9th of April, 9th of May.
This is 10, it's a series matter. Item 10.
No, item 8.
Item 8, okay.
Item 8.
I appear for the respond number 8. I have filed my application.
So, okay. It is submitted that the respondent number 8 has filed an affidavit in opposition today. Accordingly, learned counsel for the petitioner prays to respond to such affidavit in opposition if so advised. Full stop. A prayer is allowed. List this matter.
On 9th of May,
9th of
I'm obliged.
deeply obliged.
May it please your lordship. Your lordship, I beg to mention item 36 on behalf of my senior, Mr. Gauhati. He's indisposed and his name is reflected in the cost list. I pray that,
36
yes,
for respondent number
1.
1. Learned counsel for the respondent number 1 prays for and is granted.
2 weeks.
6 for an adjournment. Prayer is allowed. List this matter after
2 weeks.
2 weeks.
Your
So
lordship,
36 and 37 same.
yes. Item 36 and 37.
37 common. It's
Wait.
take together. Yes.
I also beg to mention item 66. Since my senior is indisposed, if the matter can come up after 2 weeks.
2 weeks same. Model.
And item 48.
Item
48.
48.
Yes.
48 along with 49.
Yes.
50, 51.
48.
Huh?
48.
48 is with, okay, 48, okay.
And also item 68 and 69.
60,
68 and 69.
okay, 68 and 69.
2 weeks.
Next, Lordship.
Hmm.
In 68, 69,
Hmm.
previously were engaged for EPC,
Hmm.
but now the CJC was taken over.
Okay.
Our names will be deleted, Lord.
Okay, it is item 68 and she has submitted that the brief is now, the brief is now been handed over to CGSC.
CJC, Mr. Gauhati, yes.
CGSC, Mr. CGST, and therefore the name of Hoseko Kotena,
Yes, sir. Lordship,
name of the earlier council,
Mr. Dr. Ankit Todi,
just Miss Dr. Ankit Todi,
Jose Fote, and Medovero.
just give the list,
Yes.
may not be reflected in the cause list.
Lord.
Hmm?
Obliged.
No, just give the three names.
Lordship.
Obliged.
Obliged.
And Meadow Hero.
Medovero.
Okay, three names are there in the cause list. Dr. Ankit
Yeah,
Todi,
yes.
Foseko Forte, and Meadow Hero. Okay.
May it please your lordship, I beg to mention item number 4 and 5. I'm appearing on behalf of my senior learned counsel and Longcomer. Since he's out of station, please kindly grant us 3 weeks
Item
time.
number 4, you are for the petitioner?
Yes, review petitioner.
Lordship, I'm going to respond in this case.
Yes.
This review petition is pending since completely pending.
Hmm.
So immediately we consider next week.
Your lordship, next week, 11, 12, 13, 14, I think it's holiday. So after, maybe after that.
15th?
15.
15th.
Okay.
15th or 16th as in?
16,
16th.
much obliged.
May I please, your lordship, I beg to mention item number 65, 55 to 65, lordship. In item number 65, I'm for the private respondents.
Just a minute. Item number
65,
55.
65.
65.
It's clubbed together with 55 to.
It's clubbed together with not only 55. It starts from 49.
Lordship, it starts from 55.
Huh?
55. It starts from 55
Okay,
till
55.
65.
Okay.
Lordship.
What is this? You are for?
I'm for the private respondents, lordship. Private respondents is from 7 to 101 in item number 65, lordship.
Now you are representing in item 65.
65, lordship.
Now what about the others? This is a serious matter. Have you taken consent?
Lordship, I've taken consent
From
from
the petition.
from the petition, lordship. To file my,
Yes.
I'm for the petitioner.
You don't have any objection.
Yes, no objection.
Okay.
lordship, I have not filed my counter yet since we received our copy only in the last
But this is
occasion.
pending since 2022 anyway. For respondent number
7 to 101.
in all these petitions.
No, only in item number
And
65.
what about the other respondents pleading in other cases?
I'm for item number 59 to 61.
You are 59 to.
61. 59,
Then
66.
you are for a petitioner.
Private respondents.
Private respondent. Have you filed affidavit?
Mr. Lordship.
You have filed. Okay.
Your lordship, in this case, so far as the other responses are concerned, like, pleadings are complete. The only thing is that in this case,
Okay.
only on last occasion
Okay.
they've entered appearance.
Okay. Good number. This in this series of writ petitions, the pleadings in respect of the other respondents except the respondent number
7 to 101
7 to 101
in
in WPC 199/2022. Except 2022. It is submitted that the said respondents has recently entered appearance and therefore they require how much time?
3 weeks, lordship.
3 weeks time to file affidavit in opposition. Accordingly, the matter stands adjourned to enable the respondent number 1 to so and so in WPC so and so to file their affidavit in opposition. List accordingly.
Obliged, lordship.
3 weeks. Huh?
May Mr. Lordship,
Hmm.
I would like to mention item number 6.
Just a minute. So 55 to 65 gone. Okay. Item number
Item number 6, Your Lordship.
6.
Your Lordship, kindly grant us 2 weeks' time to file our reply.
You are for
The petitioner, Your Lordship.
petitioner. Learned counsel for the petitioner prays for and is granted
2 weeks' time.
2 weeks time to file reply affidavit. List accordingly.
Your Lordship, I'll also like to mention item number 7.
7, yes.
Your Lordship, here we have to file withdrawal affidavit. So kindly grant us 1 week time.
You are for
The petition,
same reply affidavit.
no, we have to withdraw.
Withdraw.
Yes, so we are going to file a withdrawal affidavit.
Okay, the learned we'll just adjourn it. Whatever you want to file, you file. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed
After a week.
after a week.
Your Lordship, again, item number 40.
1440.
If this matter can be fixed on 8th, Monday.
Why?
Well, for respondent number 6 here, my senior is out of station, Your Lordship.
What are the issues here? Are you aware? Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed. Pleadings are complete.
Yes, Your Lordship.
Huh? Pleadings are complete in this case, otherwise we will not list it.
Number 40.
42, 44, pleadings are complete. Government has filed affidavit. Huh?
Yes, Lord.
Yes, okay, on Monday. On Monday, right? On 8, na?
Yes, Your Lordship.
On 8.
May I please, Your Lordship?
Yes.
Lordship, I'm appearing for the petition of, in item number 40 to 44. Lordship, if this matter can come up after 2 weeks, Lordship. On 8, we have some personal difficulties.
Okay, okay. After 2 weeks, 40 to 44, isn't it?
Yes, Your Lordship.
After 2 weeks.
Much appreciated.
Yeah, this Lordship.
Mm.
Lordship, I beg to mention item number 9 on behalf of Pichano. If this
Item number 9,
Lordship,
okay, on behalf of,
Pichano Lordship,
okay.
government, state respondent Lordship,
Respondent,
state respondent's Lordship.
affidavit not filed,
Affidavit has been filed,
but
Lordship,
you need an adjournment.
Lordship,
Okay.
after 3 weeks.
On the prayer of the state council, learned state council, the matter stands adjourned and be listed
After 3 weeks, Lordship.
after 2 weeks.
Lordship, similar prayer for item number 22.
20, but
22, Lordship.
20 is 22.
22, Lordship.
22 also. Yes,
Obliged, Lordship.
yes,
Next, Lordship. Lordship, I beg to mention item 67, Lordship.
67.
Lordship. Lordship, I'm mentioning on behalf of my senior, Mr. P.P. Paul.
Okay.
Lordship,
PB
if
Paul.
the matter can come up on the 6th of May. It's a
6th
consensus date. Lordship.
6th of May. As agreed to by the learned council.
Lordship, so item number 38,
38.
Lordship. Here I'm for the petitioner, Lordship.
Hmm.
So if the matter can come up on 6th of May.
6th of May.
Today.
On the prayer of the
38.
petition.
Lordship, there is an interim.
Interim order passed earlier shall continue till the next date of listing.
Lordship, I may be allowed to mention item 49 to 51, Lordship. Here we have received the affidavit in opposition.
You have filed affidavit of opposition.
No, we have received that,
You have received.
Lordship. So fairly allowed us to go through the affidavit and if need be, we'll file reply, Lordship.
Item number
49 to 50, 49 to 51.
Just a minute. When it is filed,
Last week, Lordship.
it is submitted by the learned counsel for the petitioner that an affidavit in opposition has been filed. Accordingly, it is submitted that petitioner may be allowed to go through the same and respond if so advised by filing reply.
After 3 weeks, Lordship.
Accordingly, list this matter after 2 weeks.
Highly obliged, Lordship.
Anything will remain in the list?
Yes.
Yes.
Lordship,
Hmm.
please allow me to mention item 23,
Item
bill
twen-
application 2-3 of 24. I'm
item
missing,
23, yes.
I'm missing on behalf of the leading counsel, Srirang Suman Sharma,
Hmm.
as he's coming up on March 9.
Okay.
Please,
This bail application,
yes, my lord. Please, fix it
Inside
on
jail,
March 9.
inside jail,
Yes, my lord.
search seated.
No, yes, my lord. Yes, my lord.
Okay. When?
On 9 March.
9th of March. March is gone. Now we are in
Oh,
April.
April, I beg your pardon.
9th April.
Yes, ma'am.
Okay, 9th of April.
My lord, actually, the item is mentioned under admission, but it is actually for motion, as the notice have not been issued yet.
Okay,
Yes,
okay.
my lord.
Come on, list this matter on 9th of March in the motion column.
And my lord, the name of the council,
9th of April, huh?
the name of the council, sir, Councilman Sharma may be reflected in the cost list, as he have also filed in the Bangla.
Registry also to reflect the name of the learned council for the parties in the cost list.
Yes, my lord.
Your Lordship.
Yes.
I'd like to mention item number 52 to 54.
50,
50,
you will have to pay cost. You have made highest number of mentions, 52 to
54.
all series matters you have, we got adjourned. Yes,
Your
who will
Lordship.
pay us the cost for our burning midnight candles? Yes, 52 to
54, Your Lordship.
you have a petitioner.
Yes, Your Lordship.
When?
After 2 weeks, Your Lordship.
After 2 weeks.
Much obliged.
Yeah, please, Your Worship.
Yes,
My Lord, Your Worship, I beg to mention item number 27. That is a contempt.
27.
27,
Okay.
contempt. Your Lordship, here we have taken several times
Hmm.
for filing the affidavit. And again, I represent a respondent number 4 and 9.
Hmm.
And my learned colleague, LG Sandam, he represent for respondent number 7 and 8.
Hmm.
So on several occasions, we have taken time.
Hmm.
But respondent number 4 and 9,
Hmm.
which I defend, I have received the instruction.
Hmm.
So I need some more time to file a
What is the direction?
direction to file the compliance of the.
No, direction as regards the, in the original order, what was the direction? That they have LS contempt.
Yes,
What was the original direction?
Lordship, the direction of this honorable court. My lord, it is a long checkered history. This is going to be a third round of petition. Lordship, initially the division bench of this honorable court give a direction to constitute a committee, expert committee, to examine the pay honorarium being paid to the village cards of Nagaland.
Okay, okay.
Then, Lordship, it was partially compliant.
Hmm.
So, my lord, we came back again and on the condition that as in terms of the judgment of the Honorable Supreme Court, partial compliance is no compliance.
Hmm.
So this Honorable Court give a further direction on 5 December 2022 to reconstitute the committee again and examine all over again.
Hmm.
That was the direction. Accordingly, in terms of the direction of this Honorable Court, second committee was constituted. Now, what has happened is the second committee which has constituted has simply reiterated the decision of the first committee.
Okay.
That is the issue pending.
Hmm.
Lordship, the village cards are
Okay, now he's seeking an adjournment. What is it?
on
What is-
20th of February, last chance was given. Then on 14th of April, March, when the matter came up, we did not object, saying that, okay, now this is, thereafter, this is the problem. So my respectful submission is that if you want time, I leave it to your lordship, but in the even it is.
To file it.
Yeah, definitely.
Why, what is the difficulty with this pending? Because see, contempt, we are a little bit serious.
Yes.
So we do not know. We'll go through it whether contempt is made or not, because in contempt, it says quasi-criminal proceeding. So you will have to file an affidavit.
So-
Otherwise, you'll accept that you have committed the contempt.
So by respectful submission, in the event of non-filing of an affidavit,
We'll
on
proceed.
the next day,
We'll proceed.
proceed on the.
Give a
basis
date
of the-
specific
Yes.
time that you can file it. We'll
Yes.
observe that.
Lordship, we kindly give a date. Within that, if not filed, then it will proceed.
Be assured. Be assured that you can file it by that
Yes.
date. Give the file, give the file.
Lordship, we kindly see the 20th February order, then 14th March order.
What is the date? Tell us.
7 May.
7th of May. Okay. The present contempt petition is filed assailing non-compliance of judgment and order dated 29/1/2021. Is that it?
Yes,
29/21 in writ appeal 1 within bracket K of 2018.
and as well as
And
5/12/2022 pass in this.
as well as 5/12/2022
pass in the present contempt.
passed in the present 22. Where is that order?
5/12/2022.
Okay. Uh, Just a minute. The learned counsel for the petitioner. 5/12/2022 passed in this case whereby further directions were issued.
Yes.
Further directions were issued. Full stop. The learned counsel for representing
Respondent number 4 and 9.
Restaurant number 4 and 9 seeks an adjournment for filing an affidavit in opposition. The learned senior counsel for a petitioner submits that it is seen that this matter is pending since the year 2022, and even after grant of several dates, the respondent number 1, 4 and 9.
There are so many respondents here.
No, you respond
4 and 9.
4 and
it is
9
For me
had-
and
and has
7
not
and
filed
8.
any affidavit.
Another respondent, 7 and 8, it is represented by my.
Not yet filed
Learned colleague.
affidavit. Full stop. In view of that, let this matter be fixed on
7 May.
7th of May 2024, and the respondent shall file their pleading on or before the aforesaid date fixed. If no such affidavit is filed, this court may proceed with the contempt without the pleading of the petitioners.
Lord, respond this.
Lordship, as far as the respondent number 1 is concerned,
Hmm.
our role is only limited to.
No, we have said your role is limited. Tell by one line that we
Yes,
please,
yes.
we don't have any responsibility.
Yes.
That is what is required in the contempt.
Correct.
So that we can consider that he has taken his stand, this is the stand, he is absolved from the contempt.
Yes.
That is what. You find a one-liner affidavit that I have not involved.
In fact, Your Lordship, the committee that has been constituted is already placed before my lord. It's already there.
The issue is little file an affidavit.
Okay, you file an affidavit. Okay. So I said, complete the pleadings. If you think that no affidavit is required, no affidavit is required. That's all. We have not forced you. You said that you file it. If not, we'll proceed.
Okay.
Yes.
You may say on that day also that no affidavit is required because I don't have any role. Matter ends there.
Much obliged, Lordship.
Yes.
For motion, item number 1.
May I please, Lordship. Lordship, this review could not be pleased for want of appropriate bench for the last 1 year or so.
I do not think this is a case of review. This is a case
Yes,
of
proceed.
correction of a
Yes,
typographical
Lordship.
error. This is not a case of review. Where is the respondents? You are there.
I am also supposed to be one of the respondents, but they have not embedded me as one of the respondents.
Lordship,
And incidentally, in the judgment also, our
Yes.
party, my name has not been reflected also as a party.
Okay,
Apparently, because of that, they have not met me as a party respondent.
okay.
But so far as
But
the
this,
correction is concerned,
this was not taken to the upstairs.
it is pending, Lordship.
It is pending. Okay. This
pending
requires
before
to be
the
taken,
otherwise, yes.
it requires to be taken to the upstairs so that we also know that it's a correct or not.
Oh,
Anyway,
yes.
so we'll direct this registry, direct the registry to convert it into a miscase for correction of the earlier order and list along with the dispose of matter on Monday.
Monday, are we available?
Okay. We'll just correct it. Apparently, it's a mistake.
Yes, only the word.
Only the word.
Respondent in the petition has to be.
Yes, yes, yes. After going through this review petition, this court is of the view that the error basically relates to, primarily relates, as error relates to, not basically primarily, error relates to a typographical error, rather any error apparent on the face of the record. Accordingly, the registry is directed to register the present review petition as a miscase and list this matter on Monday is a 8, na? 8 along with WPC number 71K 2010 within bracket since disposed of.
Lordship, it could be IA.
IA or miscase? IA. IA.
Last Lord.
I think that will resolve the issue. Otherwise, we'll have to issue a notice in review. Then review will recalling the entire judgment, which we cannot do. Yes.
Oblige.
For motion, item numbers 2 and 3.
Yes, what is your case?
Lord, the instant IA
Hmm.
is filed to bring on record the checks which were dishonored on 31/1/2024 and 21/2/2024, which I've annexed on page 24 to 27.
What is the main revision relates to?
The main issue is that the petitioner in the criminal revision
Any direction to bring on that on record?
the Honorable Court
Huh?
file is order dated 14/12/2023.
In the criminal petition? 14/12/2023. Okay, okay. In terms of this order, you have filed the IA.
Yes, my lord. My lord, both the parties have executed a joint affidavit on 14/12/2023, ensuring that the petitioner in the criminal revision will pay all the dues amount on installment, on 5 installment. But the petitioner in the criminal revision have not honored the check on 4 occasions, my lord.
The present application is filed. Present application is filed to bring. Generally, it should be an affidavit. Why application? What is your prayer?
My prayer is that, my lord, the Honorable Court has stayed the proceeding of the criminal complaint, which I filed before the
Registry.
magistrate in Kisri.
Okay, so a notice will have to go in this application.
Yes, my lord.
Since an IA.
Yes, my lord.
The present application is filed for bringing on record two check dated two check bearing number in its syllabus page 2 pencil mark dated Swensu dated Swensu issue notice returnable after 3 weeks. Petitioner to take steps for issuance of notice both ways.
And my lord, just on 3 April, another check
was again dishonored.
You keep it for some time instead of filing an IA.
Yes.
Your statement ought to have been that I want a oral permission. So then you will have to bring it not by an IA. It should be by an affidavit.
Yes, my lord, but the order dated 14th of 2023 is stated application, my lord.
No, that application is something different. Where is that? Order dated 14/12.
Yes, my lord.
Where is that? This. No, that I have seen. 14/12. That is here, but there is no application. The present application is price so. In the background, application price. The such application is filed in the backdrop of the observation made by this court under its order dated 14/12/2023, which 14/3/2023, which is quoted herein below. Full stop. Quoted herein below. Accordingly, the petitioner is permitted to bring on record. None appears for the they otherwise they appeared.
The consuls have withdrawn. But they forgot number.
But on last occasion that the
I think it's a mistake of the registry as the name reflected. But on the earlier date, they have all withdrawn their
so issue notice. Or if take steps since they have withdrawn, issue notice, you have quoted here in below 14/12 for paragraph 4, quote it, then issue notice returnable steps.
For admission item numbers 10 to 21.
May it please, my lord. Lordship, the last order in IA 31/2024, UGC
Item
10-2,
last order dated.
that is
No, what you want to say? This is item number 10 to
10-2, analogous matters.
Okay. Now what is the issue here?
This is appointment on through backdoor, assistant professor. So last time, this honorable court has directed for implementation of UGC.
Okay.
So we have sent through registry. So whether the acknowledgement receipt has come or not, that I'm not aware, Lordship. Order is 29/2/2024. The last
Orders dated 29/1/2024.
29/2.
29.
Yes, Lordship.
Nothing is there.
29/2/2024.
2024. Okay.
Yes, Lordship.
Okay, just a minute. I was looking. I was in the year 2023.
Lordship. Paragraph 8.
Okay. You made a submission that appropriate application should be filed in that regard.
Yes, so we have already done.
Before the registry?
No, application already, IA 31/2024 was filed.
That was allowed.
Disposed. Notice has been issued.
Notice has been issued.
So whether the service notice of UGC.
So we want to go through that IA first, is not it?
No, that has been disposed.
Disposed, Lordship.
It's disposed. Notice has been issued to UGC. And whether the service report of UGC is completed or not, that's
UGC.
unknown.
There is no kindly go through it. There is no office note, then we'll pass an order. Where is give me the IA?
No.
IA disposed of IA. we'll pass an order in reference to that because nothing is there.
14.3 dispose on 14.3/2024.
Okay.
Is it dispose on dispose on it? I think I say that the disposal, but it did not.
Okay, just main order, Ligyo. No, they have not done it. Okay, we'll just clarify.
Lordship.
In an connected IA being IA civil /31/2024, comma, this court under its order dated 14/3/2024 allowed implement of UGC, is that it?
Lordship.
As party respondent
Lordship.
in the connected, in all the connected writ petitions.
No, only in one.
In
188.
WPC
188
188
K 2023.
K 2023.
Lordship.
One
188. Read petition number 188.
Item number
10.
10. Okay. What is item 180? This is 208.
No, not 10.
Item 11.
Lordship.
Ah,
My
that's why.
apologies.
Kindly see item number 11. 188. Okay, so we are looking at some different
Lordship.
file.
Lordship.
However, come on. Come on. In terms of the aforesaid order, the UGC is to be implemented as respondent number 12 in the case,
In the writ petition.
in the writ petition.
Mm.
However, cost title has not been corrected as yet by the registry. Full stop. It is also not discernible whether not in any order of notice. You have taken steps for issuance of notice to
Of
UGC.
course, Lordship.
Okay. It is submitted that in the meantime, the
The
petitioner has taken steps for issuance of notice upon the newly implemented respondent. Full stop.
Through registry.
Through registry. In view of the aforesaid, registry shall correct the cost title by incorporating UGC
Lordship.
in terms of the direction passed by this court in IA civil so and so as respondent number 12. Full stop. And also put a note whether notice has already been sent to the said respondent. List this matter after 4 weeks.
2 weeks.
After 2 weeks, in
Because-
order to see.
Okay, after 2 weeks.
Obliged, Lordship.
Lordship, may I, I'm presenting some respondents in some matters. However, in some few occasions, our names are not being reflected. So may
Give
you kindly
give
reflect this.
registry to reflect. Just we'll write this registry to reflect name of the learned councils of the all the respondents in the cost list. That will do.
Yes.
Okay.
Obliged, Lordship.
All the respondents.
For orders, item number 26.
Yes.
Please, Lordship.
Hmm.
My lord, let this matter be listed after 2 weeks, Lordship.
Why?
Mentioned on behalf of my senior Asia, Lordship.
Judgment was passed.
Lordship.
Okay, on the prayer of the learned counsel for the petitioner. We'll go to the hearing. Or sentence, only on sentence.
Lordship,
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed
after 2 weeks, Lord.
after 2 weeks.
Much obliged.
For orders, item number 28.
Lordship, I filed this review petition, but on hindsight, it may not be a review petition, but more or less an idea on the section 152 of CPC.
Okay,
And the corrections I'm seeking is at page 20 of the petition, wherein an inadvertent mistake has been made where at clause
okay,
6,
okay.
yes,
Yeah, got that order.
those,
To this application is for filed as application for review and also registered as review petition, comma. Primarily, the issue relates to and typographical error. Accordingly, registry to re-register this case as IA and list this matter on Monday. In review, we'll have to either recall it.
yes,
We cannot pass an order like that. We'll have to recall it.
yes.
Then we'll have to pass a fresh judgment.
True.
So it's not a review.
Duly
This is only a typographical error. Okay. You just go to the registry, do whatever is required. I am here. Next week, you will finish it off.
I'll do that. Lordship.
For orders, item number 29.
Yes.
Here, the CPA, they are going to file an affidavit for causing service of notice against the respondent. Due to some technical error, slight technical error, the affidavit could not be filed this morning.
Okay.
So.
You are for CBI?
Yes, madam.
Okay.
So in the course of the day, I'll be filing the affidavit. So this matter we came up on Tuesday for necessary orders. Monday.
Next coming Monday.
Yes, coming Monday.
Lordship, I have the instruction to appear for respondent number 3 here. I'm here to file my affidavit.
This IA is filed for?
IAA, this present IAA is for continuation of delay of 55 days. And the next IAA is for restoration of the appeal dismissed for non-prosecution.
Criminal appeal?
Yes.
It's a appeal against acquittal?
Yes.
Can it be dismissed for default, criminal appeal?
That is the reason behind it, my lord. It should
Now,
not be.
what kind of affidavit you want to file?
By this honorable court, the CPI was given a direction to cause service of notice through dusty service.
Okay, dusty notice.
Yeah, dusty notice. So
upon whom?
For the against respondents, 1, 2, and 3.
And you are for?
I'm for respondent number 3.
3 has appeared. You have no instruction for 1 and 2.
Lordship, I don't have that.
Okay. On the prayer of the learned counsel for parties, list this matter on Monday, 8.
Much obliged.
Okay, we Monday or Tuesday. Okay, tomorrow days is there, Friday is there. Okay, you just take this affidavit.
Yes.
For orders, item numbers 30 and 31.
Mr. Lordship.
Yes.
Lordship, in the last occasion, this court has allowed for a split post upon the opposite parties. Now that has been completed and it has been delivered, and to that effect, I'm allowed to.
What happened on last occasion? Which order you are talking about? Order dated? Order dated 11/3.
Yes, Lordship. In that, the court has allowed for a split post for service notice. That has been completed and it has been delivered. However, none has entered appearance. So, if this court may allow us for a substitute notice through paper publication.
Through paper publication.
Yes.
Where is the paper?
No, if this or a court can come, allow today, then.
Okay, you want, it is through paper publication. Now, what about this affidavit? You have taken speed post.
Yes,
Where is that
Lordship.
speed post or direction?
It's annexed with the affidavit.
Huh?
It's annexed with the affidavit.
No, any order for that?
No, Lordship.
Now, over and above, you want to have a paper publication. Okay. It is submitted that though the learned counsel, though the petitioner has taken steps for issuance of notice upon respondent numbers
1 to 10.
Respondent numbers 1 to
10.
10 through speed post. Speed post. This petitioner further wants to take steps through substituted mode and through paper publication. These people belongs to which state? Nagaland?
Yes, Lordship.
1 to 10?
Yes, Lordship.
Okay. Prayer is allowed accordingly. The petitioner is permitted to take through paper publication. Notice is made returnable on give a date after 6 weeks. May 16th of May. Such publication be made within a period of 2 weeks from today. Thereafter, the petitioner is to file an affidavit, not you, the petitioner, is to file an affidavit annexing the original copies of the newspaper. Okay?
Yes, Lordship. Much obliged.
Newspaper, give a newspaper who is having highest circulation in state of Nagaland.
Nagaland Post.
Nagaland Post. You take back this. This is not the way to file affidavit. You will have to give it to the registry. Registry will give an office note. They will verify.
Orders up to item number 32.
Yes, Lordship. Lordship, service upon respondent number 5 is still has returned unserved. So Lordship may be permitting the petitioner to take through Dusty.
Okay. In view of office note dated, which office note 25/1, 25/1/2024 and 23/1/20, 23/1/2024 and 25/1/2024, the learned counsel for the petitioner submits that he may be permitted to take Dusty service upon respondent numbers
5.
5. Prayer is allowed. You will have to take through registry, huh? And
Lordship.
file an affidavit.
Lordship, after 4 weeks.
After 4 weeks.
Lordship, but there's an interim.
Interim order pass earlier shall continue till the next date of listing. But you file an affidavit giving
Lordship.
that I will go through the order. We'll give the details how to.
Lordship. Highly obliged. Interim may be continued. Interim.
Till the next date of listing.
Obliged.
For orders item number 33.
May I please, your Lordship? Lordship, on 15/12/2023, Lordship, we have issued notice upon the performance.
When? Last notice was issued when?
15/12, Lordship, 2023, Lordship.
Upon respondent number 5 and 6.
6, Lordship. 1 to
Six.
5 already appeared, Lordship. By
5 appeared.
Yes, Lordship.
Now what to do?
Respondent, we are not sure whether the notice has been complete upon
Not
respondent.
complete. Notice is awaited.
Lordship, then after 2 weeks, Lordship.
But it is we are awaiting since 2012.
Lordship.
So
Lordship,
take a
in that
fresh
case,
steps.
Lordship, will
Okay.
serve Dusty, Lordship.
Through Dusty upon respondent number 6, in view of office note dated 8/3/2024.
Much obliged, Lordship.
For orders item number 34.
May I please, Lordship? Lordship, here on 26, we have already issued notice to the respondent, Lordship. So we're not sure.
Notice Steps for issuance of notice was taken on 18/3/2024. Upon respondent number,
There were sole respondent, Lordship.
upon the sole respondent, await service report and list after 3 weeks. With an updated, await service report and list after 3 weeks.
For orders, item number 35.
This Lordship.
Hmm.
Minor notice was issued upon respondent 2 and 3 on 21/2/2024.
2 and 3, respondent number 2 and 3,
Yes,
await
Lordship.
service report. After 4 weeks.
Acknowledge, my Lordship.
Same I got 2 this now.
For hearing, item numbers 45 to 47.
I think there is an adjournment taken, no? 45? No, okay. 45 to 47.
Yes, ma'am. Yes, Your Lordship, may I please?
Yes.
Your Lordship, in the instant matter,
Hmm.
these are all 3 analogous cases.
Hmm.
And the facts of the case more or less similar.
Hmm.
In the complaint petition,
Hmm.
it is alleged that there is one witness number 2
First,
in
tell us what is the subject matter. It's a quashing, it's a convenience,
quashing, Your Lordship.
quashing of?
Criminal petitions, which is
No, quashing of what?
Complaint petition as well as all the consequent proceedings.
Complaint petition.
Yes, Your Lordship.
Filed by respondent number?
Since in all the 3 petitions, only there are sole respondents.
Hmm.
So actually, here all those 3 respondents, they have filed a complaint against me.
3 respondents jointly file one complaint.
No, separately.
Separate 3 complaints against you.
Yes, Your Lordship.
Containing same thing.
Yes, Your Lordship.
Okay. Now you want that complaint was cognizance was taken
Yes, Your Lordship.
and registered under cognizance under which section?
420, 430, 406, Your Lordship.
420, 406.
Yes, Your Lordship.
Now then you come before this court for quashing.
Yes, Your Lordship.
Where is the complaint?
Your Lordship.
CR case 03.
Your Lordship, this is criminal petition 12.
No. Complaint case is 03 of 2021.
Yes, my Lord. Yes.
One is 03 of 2021.
Yes, my Lord. That's pending before the Tima procedure. Then thereafter there's another 2 criminal complaint before this.
Who is
Kohima,
this?
Kohima.
Okay, so you are representing Deepak Chand and Preeti Chand.
No. I'm representing the petitioners, Your Lordship. I'm for the sole respondents.
Okay, who is Toekali Sema?
Lordship, I'm appearing for this.
Toekali Sema, okay.
Yes. In fact, Lordship, criminal petition 13 consists of all the parties. So in the last occasion also, we have referred to that petition because by and large, all the documents referred is contained in that petition, Lordship. So for the convenience of this Lordship, if we can refer and rely on criminal petition number 13.
Item number. So your whole case is that it's a civil nature.
Definitely, your lordship, but there are also other grounds.
Hmm.
So my other grounds is that
Hmm. Which you said which item to look into? Criminal Division 13.
yes, my lord.
Yes. Proceed.
Yes, your lordship. In all the three complaint petitions, the fact is that in all the three complaint petitions, there is witness number 2 by the name Rajiv Chopra. And this Rajiv Chopra, he belongs.
Yes.
Yes, your lordship. This witness number 2 in all the three complaint petitions by the name Rajiv Chopra. He is the person, as per the complaint petition, who had introduced all the petitioners with the respondents. And this Rajiv Chopra, he is also, who is witness number 2 in the complaint petitions, he is also from Dehradun, Uttarakhand. And all the accused persons in the complaint petitions, they are all from Dehradun and they are neighbors. Now, as per their complaint petition, since this Sri Rajiv Chopra was the person who introduced them for supplying basmati rice. So, and as the complaint petition says that they have also visited my location and they have seen my paddy field. And accordingly, there was a verbal agreement for supplying this basmati rice by me to the respondents. So here, Lordship, that is the whole facts of the case. So here, Lordship, what I'm trying to say is that, first of all the respondents, they are running their respective firms. So you being the owner of the firm, it is quite unimaginable or beyond imaginable that you would supply me such huge amount of money without entering into any written agreement. In their complaint petitions, they have stated that it was a verbal agreement. Number one, your lordship. And number two, your lordship, they did not produce in the complaint petition any land documents where it has been shown that I am possessing such plot of land and I have a petty.
What are you arguing, mister? Is it a determination to be made under 482?
No, your lordship. What I'm trying to say is that.
Can we determine who is having land, whether there is a verbal agreement or not?
No, your lordship. What
you come to the substantial. We will see whether any prima facie case is a bare perusal of the complaint, treating everything to be correct. A case is made out or not. That's all.
Yes, your lordship. That is what. that is what, before coming to the real point, I was just giving the
There,
background.
come to the real
Yes.
point. Come
So-
to the real point.
Okay, your lordship, so.
See,
Here-
in a 482 petition, we cannot go what should have been, what should not be, until and unless it is absurd. There may be verbal agreement, no problem on that. You might have a land, you might not have given them the land document. These are not issues. Issue is whether a plain reading of the complaint without taking it to be correct, a case is made out. If a case is made out, you will face the trial. If it's not made out, you will not face the trial. That's
Okay,
all.
your lordship, in that case, as I submitted, that since this Rajiv Chopra, he is the person who had introduced all the respondents with the petitioners. Now here I have filed also my additional affidavit. During the pendency of this case, there was some kind of argument there at Dehradun. And we have filed that CD record also. This witness number 2, who was the person who had introduced, he had admitting the fact that in Dehradun, that is village called by Pali village, there is no scope of growing
Again,
this.
you are coming to that evidence. Can we take it to be correct?
No, that is what your lordship, I am saying, when their whole story is that there was agreement between me and you regarding supply of basmati
Understand,
rice.
your case is that this witness is also not believable. Can that be determined under 482?
No, your lordship.
Then you come to the basic fundamental point. Our scope is very limited under 482 so far relating to quashing of an FIR or quashing of a complaint. Okay. Law is well settled in Bhajanlal. So whether within the parameters of Bhajanlal, your case comes or all subsequent judgments. Now, if you show us, let us first read the complaint. Why should we go through all this? What is your complaint? Where is your complaint? Tell us.
Actually, I'm not a complainant. Actually, respondent, they are the complainant.
So, meaning thereby, their complaint, whether if no case is made out, we'll quash the proceeding.
Yes, then in that case, your
That is why I have first asked, let us see the complaint petition.
Okay.
You are going who stays where there is paddy field or not. These are nothing for this 482.
Your lordship, definitely, when a false case has been filed against me, then definitely court
Who
has
will
to see.
determine it's false or not false? Then every case says, one side will say this is true, other side will it is false. So this is to be determined by whom?
So that is what your lordship, is there any ingredient of the complaint petition which has been filed by the respondents? That has to be seen. That is what I'm.
That is why you come to straightway to the complaint.
Yes.
You first started with that there is verbal agreement. That it is in somewhere else where there is no paddy field. Therefore, it is unbelievable that there is an agreement for sale and purchase of basmati rice. Can these be taken in a 482 petition?
No, your lordship.
Then,
so
if no, then why are you wasting time of the court? Come to the complaint.
So your lordship, even if you if we go through the contents of the complaint petitions, the case has not been made up prima facie.
You argue that.
Yes.
You argue that.
Yes, your lordship, even for the time being, if we believe that, okay.
That is the fundamental
Yes,
in case of a quashing. That let us take whatever written is to be correct. And then if case is made out, you face the trial. If no case is made out, we'll set aside. As simple as that.
Yes, your lordship.
So let us see the complaint.
Yes, your lordship. So here, even if we believe in the story of the respondent, or so to say complainant, so as your lordship earlier said that, if that is true, for the time being, let us say that, then also this whole case comes under civil nature. Since there was an agreement, so to say, as per their claim, that there was a verbal agreement. So because of that verbal agreement, they have supplied me some amounts, and accordingly, I could not supply them basmati rice. So when there is any agreement between the parties for supplying something, then how this case will come under criminal nature? They have the alternate ways for recovery of their money by way of civil suit, if their story are to be believed. Otherwise, as I was submitting, but your lordship said that those things cannot be determined under section 482. So I'm not going into those aspects. So by plain reading of the petition also, this case clearly falls under civil nature. There is no way of incriminating me under criminal complaint.
Where is the page?
That is your lordship. Page 32, your lordship. Criminal petition 12, page number 32.
Just a minute, just a minute. Are you having Bhajan Lal? No.
No, your lordship.
That statement was recorded under 200 before cognizance?
202, your lordship.
202.
Yes, your
It was recorded.
Yes, your lordship.
Where is that?
I think a record has already been raised. This court has called for the record.
Have you annexed that? No.
No, your
There are two records. One is pertaining to Dimapur and the other is Kohima.
Where is this? Kindly flag mark. Where is the statement? Statement under 202. Huh?
Your lordship.
Initial deposition.
Yes, your lordship. What I'm trying to say actually regarding this Kohima case, what happened there at trial court was that since the petitioners, since I was from the outside state, so without complaining, they had issued me notice. So as per criminal procedure, unless and until cognizance is taken, court cannot issue you summon. So what happened accordingly, we challenged that order and accordingly that order was recalled back there at Kohima, not in Dimapur. So accordingly now, after this, we got bail. Now we have approached this honorable court. So why I'm saying this? Because definitely there was a procedural lapse regarding that Kohima case. So I don't think that this 202 statement will be there regarding.
But in other cases?
In Dimapur, so definitely your lordship.
Go to the record, because see, we'll have to consider whether criminal case is made out or not on the basis of the complaint, as well as we'll look into the initial deposition. These two parts we'll consider. If any case is made out, then we'll not interfere. Or law is also equally well settled that there is no absolute bar that when dispute is maybe relates to civil nature. Suppose you have an initial deception in your mind. You enter into an agreement with initial deception of mind that I will cheat this man. This may be a civil contract, but if there is a statement in the complaint that you have the initial deception in mind for this, or it can be gathered, why should we interfere only on the ground that it is a civil contract?
No, your lordship, that is what your lordship
is not
said
it?
that, no, definitely.
That is the law.
Definitely.
It is not that because it's a contract of execution of some work, it is civil nature, therefore you go to civil suit of recovery. Where will we go the criminal liability? Suppose you have initial deception in mind that I'll cheat this man, so therefore let me make a false promise. That is initial deception is in your mind. If that statement is there, it will be a both criminal and civil. Civil is for
Definitely,
recovery,
Your
criminal
Lordship.
is for punishment.
And in the instant case, actually, as I said, I am from Dehradun. Actually, before filing of this instant complaint
That
petition,
inquiry.
even I was not knowing the respondents.
No, that is you,
So-
you may not know, but there should be an inquiry by the magistrate if one of the respondent is outside.
That is what, Your Lordship, I am saying. Since
We are going for final hearing.
yes, Your Lordship.
In the midway, don't say that I want to have this instruction, I want to have that instruction.
No, no, no. I'm ready, Your Lordship.
Yes, yes. Mr. Zamir, ask your junior to go through this record. There may be difficulty. Just flag mark it, how it proceeded. See, a complaint is filed. Thereafter, there will be some initial deposition so that magistrate can have a satisfaction that this case is made out. Because only the complaint will not do. There must be supporting evidence. The petitioner or complainant only herself can adduce or may bring some witnesses, but there must be something. On the basis of that, a cognizance is taken. This is one aspect. Other aspect of the matter is that if the respondents are residents outside the territory of the court or magistrate, there should be an inquiry, if apparently. So whether that inquiry was done, this is second issue. Third issue, are you arguing that no cause of action within the jurisdiction of the magistrate?
Yes, Your Lordship.
That is also your argument.
Yes,
So
definitely,
go
Your
through
Lordship.
those statements where the agreement, because we will not go to all these things that whether verbal or non-verbal, there is an agreement statement is that we'll believe that there is an agreement. Okay. But if he raises the question of the cause of action, that the offense committed where, that will be a very vital. Suppose that agreement was,
Apparently, they have not raised that point.
we'll go through it, that he may raise it, because in the complaint that should be there.
Lordship.
When that offense was committed, where offense was committed, how offense was caused. So these things will require. And all these cases are jumbled up. Because in some cases, it was different, that inquiry was not done, then it was returned back. In other cases, there might be, in one case, there may not be initial stage. So that will be a different order. Others will be so. Please flag mark it. Today or next week? Today may not be possible. But I want this to be thorough. We cannot waste time looking at like this.
Lordship, so far as section 4.
He is enjoying a stay.
Lordship is really aware. And the scope is very limited, as Lordship has expressed already. Whether there is abuse of the process of the court, that is one. And if the investigating agency has exceeded their jurisdiction or they have not exercised their jurisdiction, those are the grounds where.
No, here it is a complaint case. So therefore, our determination will limit first to whether a criminal case is made out. Okay?
Yes.
If it is made out, made out.
Lordship.
Even if we held that it is made out, the next question would be whether the magistrate could have taken cognizance in absence of or any material where that evidence before cognizance, that is initial deposition, what is the reflection therein? Because we'll have to compare both. Okay, this is second. Third is as regards residence of the accused, because they have a right under that provision to first magistrate will have to have an inquiry.
Yes,
so whether those were done or not done, you ask a junior to look into the provisions from 200, na? Or 198?
From 200.
From 200. You go through it and whether these are followed.
The procedures have been followed.
Procedure. First, this case is made out on, you will argue that at paragraph so and so, we have specifically made statement that he had this initial intention. Last but one paragraph, you have made that statement. And others will look into. And there are certain judgments which you can do. Bhajanlal is there. Then there was a case.
There are few recent judgments also. Quashing is not justified by just merely making out a commercial transaction or money transaction.
No, that's true. That's
If
true.
cheating is involved, then that itself is a ground for rejecting the application lordship.
There is a judgment
investigating
and
agency should be a-
Nagendran Yadav. I forgot the citation. No bar instituting appropriate criminal proceeding in case civil court comes to conclusion. Okay.
Ramdev Uthapai is there. Captain Singh versus State of UP.
That is there. That is no quarrel. But only here we'll see. Only civil nature will not debar criminal cases taking cognizance.
Yes.
Provided a case for taking cognizance is made out. That is the fundamental. And that whether case is made out, will only look into the complaint. Not any other disputed materials. Will not look into. That is not our job under 482. And other 200 procedure. Yes. When?
Monday.
Monday?
Yeah.
You are coming from where?
I'm coming from Dumapur, Your Lordship.
Oh, no issue. Now only 1 hour.
No, definitely.
Tell us. You, as per your date, you are convenient date.
Let me check.
You check it.
Lordship, can it be tomorrow? Because on Tuesday, that is 9th, one Somoto PL registered by this noble court, there I have been appointed.
Oh, that I know that.
Amicus curiae. And I had to travel and eat. So Monday and Tuesday will not be possible. And then only after 1 day, the court will be closed again. So if
let us have his idea.
Endeavor tomorrow, Lordship.
If on 10, Your Lordship.
10th, he's out of this. 10th will not be possible. We'll have to deliver a judgment. I'm leaving.
Division bench day also.
Division bench day, 10th.
We can make an attempt tomorrow, Lordship.
If he's
Tomorrow, actually, I'm not ready, sir.
okay, on 16th or 17th. This is the issue, vital issues.
Okay, Your Lordship, then on.
But whosoever, whether I am sitting or somebody else is sitting, we will have to have record should be clarified.
Yes.
That is what I want. You flag mark it. It is your case.
Yes, Your Lordship.
You go through this record today itself.
Okay.
Huh? As agreed to by the learned counsel for the parties, list this matter on
Monday, Your Lordship, 15.
no. He leaving for
Next week, I'm not free, but.
next week he's not free.
15 is Monday.
15 Monday, huh?
15 is Monday.
15? 15.
Yes.
In the meantime, the learned counsel for the parties may go through the record, of the learned court below. Huh?
Yes.
Just go through. This is very vital. These are the points.
Yes, Lord.
Don't let us not go to who resides in where there can be basmati rice planted or not planted. These are not subject matter. Subject matter is he made a statement. There was an agreement. You promise that you will give it, and according to them, he paid money. This is a statement, and that they said that you will have to pay in advance. Accordingly paid. This is not given. Up to that, according to this is a civil contract. Therefore, in this cases, no criminal cognizance could have been taken.
No criminal
elements are there. However, he will argue that in paragraph so and so we have made a specific statement, but by doing so, this has been done. Now, whether that statement alone can be a ground to take cognizance without any specific statement that he has initial deception or not. This is a 50-50 case.
Lord.
This is a 50-50 case.
I agree.
Because your statement is also not that clear. Except the statement at paragraph 8 or 9, something like that. Absolutely like a civil nature.
But in certain paragraphs, they have also admitted in their application, the present application.
Admitted position, we can take note of it. Even certain admitted facts, if they can show that these are the admitted position, that can be taken note of. But disputed facts in 482, we cannot. And that 200 procedure.
Yeah, I did the whole thing, so it's a lesson that I'm complaining. Security laws, 400 million procedure is a policy. Is a policy. It will follow mess and then go to it. I don't want to close every civil list.
Page ni jangan extract boleh lagi mana? Boleh.
দিব লাগিব তাকে তুমি দিব লাগিব